to Supreme Justice Work had, and he should know his granted stay. That will also ultimately follow this. They have to come out if it happens. As of now, it is with Justice. So I hope that it got transferred to this. It's to my plate. You put proof that all. Please finish.
There are 9 MAs. I've been in the enlistments for 100 MAs. Who have not been participating in the Shiksha.
So, Your Lordship, sir, well aware of what transpired, once this review petition, while they're not all parties, it covers and will have an impact on about 12 lakh teachers who were in service at the time that the RTE Act section was amended.
So that is what we have held that that special 18 months course was for protecting the teachers who are already in service.
Correct. So
But it can't be made applicable for future employments. That's what we.
yes. So, the idea of Manoj was simply this, that in curriculum and in everything else, the program is exactly the same, including the internship period. It's a 24-month program.
No, it's a 18 months.
No, the program that has to be followed as has been laid down by NCTE is a 24-month program. Now, the relaxation that was provided to ensure that they fall within the timeline because Section 27 was amended and the proviso was included, which allowed those in service to complete by 31st March 2019, which required it to be completed in less than 24 months. So that's why the relaxation was brought in, so that they will finish in 18 months. Now, what has happened is, this, that 18-month period is being treated as equivalent, not by the Uttarakhand High Court. Your Lordship judgment says that the High Court couldn't have gone in and created an equivalence. That perhaps is not what I think would be borne out from the record to us, because there were actually an expert committee that had been set up by NCTE. All this took place on directions which were directed by the central government by exercising its powers under Section 29. There were advertisements which were issued with the Prime Minister's photo on it, saying that please ensure that you will complete this by 31st March 19. The idea was that once, as an in-service teacher, I get that qualification of 18 months, it is exactly the same as anybody else getting a 24-month qualification. Now, the effect, my lords, of your Lordship's judgment is that in schools, for example, which have gone through the plight of COVID, who have had to close down, etc., those teachers, when they step out and they apply, they are told that, sorry, this is not being treated as equivalent to the 24-month. That is the problem. It is, in fact, I just wanted to show your Lordship 3-4 documents, which will show what the background is. What took place is, and all this took place over a short period in the middle of 2017. The first thing that took place is that the MHRD issued a letter to all the secretaries. MHRD said, look, we have found that there are in-service teachers and we must take care of them. So MHRD tells the secretaries that NIOS will be the institute, and through that we will have this course. The idea throughout, and there has been no specific different stand that has been taken either by MHRD or by NIOS or by NCTE or by any of the universities or any of the state governments, that the 18-month program was to ensure that those in-service teachers will get the same qualification that those otherwise would have the benefit of getting over 24 months. The others could take 24 months over it languidly because they were not in service. Those in service, if they have to take a full day 24-month course, they can't also be teaching at the same time. That's the practical difficulty. So what the MHRD did is, this was on 3rd August 2017. Barely 6 days later, the amendment that they suggested gets the approval of the President. The amendment that is made to the section. Which is why on 21st August 17, all this is taking place in the same month, in August 2017. On 21st... Sorry, I'll just take your listen in just 2 minutes. 21st August 2017, in the same month, MHRD writes to NCTE under Section 29 of the NCT Act, directing the following relaxations. If for a minute, I can just read out Section 29 of the Act, because that is relevant. That's where all of this starts, fellows. NCT, yeah. NCT, National, तो शायद इसके अंदर होगा, check it. NCT. No, NCT, the National Clarification. I'll just have this one. I'm sorry, no, one copy, that's mine. Section 29, if your Lordship sees. It gives the central government the power power of relaxation. So this is taken at the highest level. It's not that the High Court in the impugned judgment decided the equivalence. The relaxations that were directed in exercise of this power by
the council shall in the discharge of its functions and duties
yes.
under this act be bound by such directions on questions of policy as the central government may give in writing to it from time to time.
Correct.
The decision of the central government as to whether a question is one of policy or not shall be final.
Fine, correct. So on policy decisions, therefore, Section 29 is the central government's power to give those directions, and the NCT doesn't have the option of saying, no, this is not binding on me. NCT has to follow suit. Now, this takes place on 21st August 2017. Now, we have a convenience compilation given your lordship, which shows what they've done under the Section 29 in the same month, which is on page 53 of the convenience compilation. Second convenience compilation. Page 53. Second one.
Yes.
This is your lordship, page 52. This is regarding training of untrained in-service elementary teachers in these schools. An amendment to Section 23(2) to extend the period for such training to 31st March 19 has been passed by Parliament. Your lordship will see
Where are you reading? Page 53?
page 53, the first paragraph. This is 21st August 17 letter, Manoj. Yes.
This is regarding training.
Yes, regarding training of untrained in-service elementary teachers in government schools, etc. An amendment to Section 23(2) to extend the period for such training to 31st March has been passed by Parliament. Please note the date is 21st August 17. So therefore 2 years are not available now. It's only till 31st March 19. In this regard, it has been decided that NIOS will be the singular organization responsible for conducting the online D.El.Ed program through the SWAYAM portal, etc. The tentative number of in-service untrained teachers at elementary level is 11 lakh. That include teachers working in government, government-aided and private unaided schools. However, the actual number may change. NIOS will be completing all academic activities related to above training by 31st March 2019. This is for the same D.El.Ed to get that qualification. To ensure the above training through NIOS, NCT is directed to provide following relaxations under 29 of the NCT Act, which your lordship just saw. So this is the government's direction. Teachers who do not fulfill the minimum eligibility requirement for taking admission in D.El.Ed program, 50% class 12, will have to join NIOS and reappear for class 12 exam to achieve minimum qualification. NCT shall allow such teachers to take provisional admission in D.El.Ed program of NIOS, subject to them acquiring 50% marks in class 12 before completing the D.El.Ed program of NIOS. This would facilitate such teachers to pursue both courses concurrently. This is important, it's concurrently. The D.El.Ed course will be from 3rd October 17 to 31st March 19. This is the D.El.Ed course. The duration of the course will be for 18 months. As the D.El.Ed program is of 2-year duration, NCTE shall allow subsuming of 6 months internship period within the duration of the proposed online course through the SWAYAM portal, as all the teachers are in service and are already teaching.
So therefore, all the teachers are in service.
Exactly.
And are already teaching.
Correct.
So therefore, we said that such of the teachers who are in service
Yes.
will be protected.
Correct. Now will be protected, but the online D.El.Ed course that they have done, which is an 18-month course, will permit them to have the full D.El.Ed qualification as is required under the Act. So the minute I finish this online course, Lord, which includes the 6-month internship period in it, therefore 18 plus 6 is effectively 24 months, effectively that, I have the full D.El.Ed qualification as is required by the NCTE for the purposes of the RTE itself. So for the purpose of 23, I have to have the qualifications with the NCTE will lay down. NCTE says for D.El.Ed you need to have a D.El.Ed 2-year course. That's what NCTE says. Now the ministry gives a direction saying your 24-month course cannot inure to the benefit of teachers who are in service who don't have 24 months available to them by 31st March 2019, which is why this sentence is important, if I may read that. As the D.El.Ed program is of 2-year duration, NCTE shall allow subsuming of 6 months internship. So while I do the 18 months, I will also be in 6 months of that, also doing the internship alongside because I'm in service. I hope I'm making myself clear. I don't want to repeat myself unnecessarily. The idea is that
The question that is whether this qualification has been made as a special provision only for those teachers who are already in service, or would also be a qualification for future.
It cannot be qualified for anybody who's not in service. It cannot.
That is what we have held.
No. So if I
The Uttarakhand High Court had held that this 18 years diploma is equivalent to 24 months, and therefore they could apply for the assistant teachers post available in the state of Uttarakhand.
But your lordships have reversed that part of equivalence, saying that the court could not have deemed equivalence. These two courses are not equivalent, is your lordship's finding.
Therefore,
the effect of that is...
are you a person who is already in service on.
We're all in service.
So they are already protected.
No, so I'll explain what the problem is. Of my life, your lordship judgment protects me. But if I want to go to another school and that school asks me where is your D.El.Ed, I show this. That school now using your lordship judgment will say, no, you don't have the 24-month D.El.Ed qualification which is required because the Supreme Court has reversed the Uttarakhand High Court's finding of equivalence. Because the lordship has reversed the finding of equivalence, my 18-month D.El.Ed course is treated as some special requirement for me to remain
State service, yes.
only in this school. But I can't move from one school to another because it's not being treated as a D.El.Ed 2-year qualification, which is what is required of the NCT. Now, apart from the impugned judgment, there are 5 other high courts which have given the exact same judgment of equivalence. 2 of those your lordships considered, which is Patna.
But Bihar and Uttarakhand.
Yeah, you dealt with Uttarakhand, but at para 32 of your lordship's judgment, you have said Patna and Tripura were therefore wrong. So the effect today, because there are other
I think Tripura was Justice Qureshi's judgment.
Yes, it was Justice Qureshi's judgment. Now, the problem is twofold. One is of movement. If I, as a teacher, want to move to any other school, I now have a hurdle where I'm being told, look, your 18-month D.El.Ed is not to be treated as a 2-year D.El.Ed. Why? Because the NCT regulations have, the overarching regulations, those regulations say your qualification under Appendix 9 and 11 of those regulations are that you need a 2-year D.El.Ed. That's what you need. So this is not technically a 2-year D.El.Ed. So the schools which say no to me may not technically be wrong. They may not be wrong in saying, look, the requirement is 2-year D.El.Ed. You don't have 2-year D.El.Ed. Supreme Court has said 18-month D.El.Ed is not the same as 2-year D.El.Ed. That's my hurdle. That's hurdle number 1. Second is, if I belong to the unfortunate few, the schools are closed for one reason or other. It could be COVID, it could be any one of other reasons. Then I'm left with nowhere to go. Otherwise, your lordships would protect me to that limited extent. And the third thing is most important one. There were 2 SLPs which came before your lordships. One was by the state. I don't know how they are agreed exactly. And the second.
We recollect Mr. Sethi vehemently argued on behalf of the state of.
So he relied heavily on the state's rules. Now the state's rules had in fact subsequently been amended. And the state's rules said, as an alternative, anything that may be prescribed.
The question before the Uttarakhand High Court was that whether such persons who were having 18 months diploma could be permitted to compete for the post of assistant teacher which are advertised.
Who are in service?
No.
It's only in service, brother.
In service.
All of us are in service.
In service. About that.
No, he's just talking about the High Court. The High Court.
As the teachers
Yes.
who are already in service on the date of
Yes.
this notification is concerned,
Yes.
there can be no dispute that for them it will be qualification requisite qualification equivalent to 2 years diploma.
That's it.
But not for the persons who are not in service on them.
That's the one sentence that your lordship is the only thing that I want. That's all.
That is what we have heard. The judgment is being misinterpreted.
The admission is interpreted, so if that can be clarified, that will be enough.
What he wants that this qualification should be held good as 2-year diploma course for all time to come for him. That is what he wants.
But the admission is a basic requirement.
The school बंद हो गया. For a reason, closure है no student. Then, though he was in service on the date of that notification.
That's it. That's only.
That's only get the recruitment. This batch of person.
If any other recruitment provided on the date of that notification, he was already in service.
Yes. That's it.
He was already.
By his service, if he attempts to switch over to some other service,
Then
he will claim benefits saying that I am in service. Even today I am in service.
on the date of notification.
On the date of notification.
On the
Any other notification.
no.
It's only the one notification.
On 22nd November, 22nd September. No, where is it? 22nd September.
The second volume we handed out page 76.
No, but we were dealing with only one notification.
So on that notification, see the
Where is the problem? If you have any problem in future vacancy, future recruitment, then you come.
No,
you are just thinking of a hypothetical situation that in future it may not endure to your benefit. Therefore, it should be reviewed.
as a consequence of your lordship's judgment, there is a series of notifications. One of them is by SN. Page 66.
Page?
Page 87, not the compilation one, not this one. The other one, Mota wala hai.
इसमें page 76 में तो some.
That's the first sentence. Now that is.
No. Where is that order dated 22nd of September 2017?
Page 63. Page 12. Page 63. difference also. This page from the page.
धीरे जी कौन सा 45 में बता रहा हूँ
It is there.
The two separate documents for your notes.
63
report Malone Justice Gawai, which is the 22nd September 17 recognition order. The third paragraph of that you can see for a minute at 63 says, whereas the said project proposal has been considered by an expert committee constituted by NCT already in front of the committee considered the project and found that the NIOS is adequately prepared to conduct the program and the curriculum proposal meets the requirements of D.El.Ed ODL program of NCT. They're giving the approval to the 18-month program saying that it meets the requirement of the 24 months. And therefore granted recognition at the end at page 65 to NIOS to have that program. Which is why if you go over to page 76, the government will just puts this advertisement out at page 76. Which says that on the request, I'm sorry. Honorable Justice, they have page 76. 76. On the request of many untrained in-service teachers who could not apply earlier, final extension is being given for registration for diploma in elementary education, D.El.Ed. This course is approved by the NCTE and MHRD. Anyone with this qualification can apply for job anywhere in India. They say this is the last opportunity for such untrained in-service teachers.
For training of in-service untrained teachers.
Untrained because we don't have the D.El.Ed. But Malone on page 76, sir.
No, 64.
Oh, 64. So sorry. 64, yeah. So one thing your lordship can take it, all of us are in service, we were untrained, we took the course, the government will get 1,100 crores from 12 lakh for us who applied, who took this course, we completed it in 31st March 2019. There's nobody else, there's no other possible kind of candidate who's before your lordship. That's point one. Point two, in those two SLPs that came before your lordship, I think your lordships were under the impression that those who had come were also D.El.Ed candidates. They were not. They were not 24-month D.El.Ed candidates who had a problem with 18-month D.El.Ed candidates. They were B.Ed candidates. B.Ed candidates, which is a qualification.
No, but that is a settled law. B.Ed is not a qualification for primary teachers.
So they come to this court and disturb the High Court's judgment is what I'm saying. They absolutely have no locus. But they misled your lordships because we took the SLP out. We filed that also. In the SLP, in the synopsis, they say we are D.El.Ed candidates. But then we find that the three petitioners were all three were B.Ed candidates and they didn't have the qualification. They could never have challenges. It was not 24-month D.El.Ed coming against 18-month D.El.Ed at all. So they have no problem. 24-month, 18-month, we're all the same D.El.Ed. We happen to be in service. So this little...
No, but those persons from Uttarakhand who had approached the Uttarakhand High Court wanted to compete in the in pursuit to the advertisement for recruitment initiated by Uttarakhand.
Because we believe that our D.El.Ed 18 months was equivalent to the D.El.Ed 24 months. We had no reason to believe otherwise. And the High Court, even the High Court, I must tell you, lordships, did not have the benefit of the document I'm showing you, which is section 29 directions by the MHRD, the expert committee's minutes. The expertise was not of the High Court. The expertise was at a policy level of the central government. The central government says that, look, this concession should be given. They're all full-time teachers. Therefore, they won't be able to do 24 months by 18.
What is your problem now?
Our problem is only this. If we are not treated as equivalent...
Who is not treating you?
All the government.
Any document?
All the government. One is page 687 of that last non-violation. The one open there. Page 687.
So you are still in job in Uttarakhand?
Yes. Most of us are... Now I will not speak very briefly. Among the petitioners before your lordship, there are a few who are in service in a particular school who want to move. There are others whose schools are closed and who are without a job. So there are both categories before your lordship, but all of them are in service teachers who finished the 18-month course by 31st of March 2019. There's no other category here before. I'm saying it with some responsibility. I think Mr.
In 301.4, all 94 petitioners are not appointed by the board in the state.
That supports what I'm saying.
They are not appointed at any stage. They are claiming to be in appointment in some management.
So they were not in service at all.
No.
So we will not go into that. How can we go into those questions?
By getting the connection, completing the examination. So this. They are ready to put it in affidavit that they have pleaded something completely contrary to what is actually there. No, they have taken the course afterwards as appendix appendix 9 course in the regulation.
He's saying
It's appendix 9 course.
In fairness, we are limiting it only to those who have taken the NIOS by 31st March 2019. We're not dealing with anybody else. If Mr. Chatterjee is right, then those people will not get it.
In fact, Lordship,
let's we stand by our statement.
2010, the training was not a qualification.
Let's
I want to first swing this.
In different matters, different states.
There have to be no social petitioners over those states. The state.
No, in your matter, who is your opponent? Which is your opponent?
State.
Which state?
Uttarakhand, no?
Uttarakhand.
Uttarakhand also is this way. Because I have the record. Lordship, can you still number? I thought. Is it everything from the figure of it?
same matter, no?
It's like doesn't that matter? Here I come in as whatever they decide. That is the most fine. This is not as the effective of a 24.
We'll have to hear the
It
state.
needs to be very good.
Unless we stand by our statement, all of we were in-service candidates.
We only consider only such persons who are already in employment
Yes,
on 22nd of September 2017.
Yes, correct. In fact, what happened is, in 2010, when the rapid came, there was no training qualification required at that stage. So, the government gave a 5-year window for getting the training done in 2015. When this was not completed in 2015, it was extended till 2017, and the extended.
We have traced the entire history in our judgment. It was a special provision to meet that deadline.
The requirement of party.
Act in the state between prior to 2017. They are not showing anything, any document.
We are not going to, even if we allow or clarify the order, we are not going to consider individual cases. We will only say
Yes, sir.
that such of the teachers who were in employment on that date to be considered as having the necessary qualification.
Because states that, because they are claiming
The proviso
Under the state statute, if they were in employment at a particular date, we will not do.
section 23, just one minute, one minute, Kunal. 23(2).
It's an aided school or government school, and we don't have a data.
No, so I'm agreeing with Mr. Chagin.
If you don't have a data, if their services are not happening, they are out of the school.
That's correct.
Yeah,
So let's just to help.
How can they claim that?
Their initial appointment was dead.
No, but then the NIOS was permitted to conduct that examination only for in-service candidates.
Yes,
The NIOS could not have considered the examination for anybody else.
They have appointment allowed. It is supposed to be done by anybody.
No.
No, not at all. Exactly.
What is he saying?
Who were in employment? If NIOS has permitted those candidates to appear, it is presumed that they will be in employment.
Well, in fact, section 23(2) provides.
But one thing is clear.
Yes.
We will be putting up a deadline of 22nd September 2017.
Yes.
Who were in employment on that day.
No, that's what I wanted to tell you, Lordship. The section requires, and I'm making it against myself, I need to be fair. Section 23(2) proviso of the Act says, provided further that every teacher appointed or in position as on 31st March 2015. 2015, that's the cutoff date, 31st March 2015, who does not possess minimum.
So then we'll put it only such persons who were in employment on that day.
Absolutely. That's the correct. That's the correct. 23(2).
So बाकी सब एमएस में अगर भी नोटिस दे देना, notice written about 4 weeks. That's what we are saying.
In all MES also makes notice needs to share.
No further hearing. We will only be clarifying this position.
Absolutely.
That has been misinterpreted because I don't think that.
So just, if there won't be any further hearing, let me show you one page 686, which I was just showing you in that fat volume. It's a notice by the government of Assam, which refers to your Lordship's judgment and says, the advertisements were prepared and published in compliance with the order dated so and so, and as you have SLP so and so, where it is stated that the qualification of 18-month D.El.Ed acquired from NIOS is no longer a valid qualification to be eligible for fresh recruitment to the post of teachers. This is with the.
We will clarify that.
Just clarify.
They will be entitled only if they were in service on 15th of.
On 31st March 2015.
So you issue notice in all the MS. Returnable. When can they be served?
As soon as we have served. Notice has gone. Just one. Notice has gone in all 9 MAs already. In the review, we are taking fresh notice from your lordships. If your lordships will give us Dasti, we've served them, but give us Dasti as well. We'll serve them again.
Reasonable on 11 December.
11 December, sorry.
City, my lords, I need 4 weeks time to file our time.
What is your stand? You are supporting the petitioner before the High Court now. You can't change.
I'm supporting.
Then for what?
I'm not supporting but arguing also.
So should we keep it in December or January? What is
December, this small clarification. I mean, there doesn't seem to be much, Carol.
reasonable on 10th of December?
Sure.
Liberty to serve the state government through standing councils.
Great.
तो 3:30 बजे